Hello, everyone, and welcome to our webinar, the Privacy and Cybersecurity in 2023, Key Trends and Developments in Canada and Abroad. My name is Alex Cameron, and I'm the co-leader of the Privacy and Cybersecurity group at Fasken. And while I'm introducing our session for today, please see the information on your screen. I'm joined today by about 20 of my privacy and cybersecurity colleagues from across Canada, which is roughly about half of our group in this area. We have one of the largest and most experienced groups in the privacy and cybersecurity area in Canada. We have an extremely full agenda today, and we're going to be moving very rapidly with developments across the country and abroad. And so buckle up and we'll get going right away. In terms of a very brief remark from myself, firstly on Bill C-26 and C-27, just by way of status update, and certain of the presentations will touch on this as we go. These are amendments to PIPEDA and the introduction of a cybersecurity bill targeted at essential and vital services, telecoms, transport, banking, etc. These are major law reform initiatives. They're both past now second reading. They are both with committees. Latest word on the PIPEDA amendments is the committee may not be dealing with this until the fall. And so we will see in the coming months ahead likely some further activities on both of those fronts, but wanted to just touch briefly on that. We could go to the next slide, please. In terms of my own presentation today, and with me will be Darren Reed from our Calgary team, we're going to touch briefly on privacy class actions update. And on that, we could go to the next slide. Very briefly, I want to just put in a very small plug, which is not class action related, although I'll tie it together here in a second, to highlight some excellent work being done by law enforcement in the privacy and cybersecurity area, and really encourage everybody to think and rethink their approach to working with law enforcement. We've seen tremendous efforts by law enforcement to disrupt attacker activities, to take down large websites which are offering up credentials and other means by which companies get hacked and privacy violations occur. This includes in Canada, and so certainly the RCMP and the provincial forces and local forces are very much involved in this. So it's very much beyond just getting at bad guys, capturing them, arresting them. That's of course a major focus as well, but there's a significant part which is disrupting the attacker activities, and that's some of what you see on the screen here. The redacted email over on the right is an example of the kind of thing you may receive from the RCMP, which is to alert you to an imminent attack. So if you do get these types of emails, pay attention to them, take them seriously. We've had clients prevent attacks from occurring in the wake of those kind of emails. We could go to the next slide. One public example of this, there was a case in 2022, and one of the prominent individuals with the NetWalker ransomware group was arrested and sentenced in Canada to about 7 years in prison, and was also extradited to the US and faced 20 years in US jail. He was a federal government worker, actually. So incredible work being done on that front, and really strongly encourage folks to rethink how they're working with law enforcement, because there are a lot of benefits that we're seeing in that space. So with that, we'll get into the privacy class actions. Jones' case was really the centerpiece. It's been around now for a little over a decade. Intrusion upon seclusion allowed plaintiff counsel to seek moral damages where there was no harm needed to be proven. 3 requirements: that the defendant invade private affairs, that the conduct must be intentional or reckless, and that the invasion was highly offensive. So these were the requirements established in that tort about a decade ago. There have been wave after wave of class actions with this as the centerpiece since that time, and with varying degrees of success. In the last year, we have some cases which have closed the door to these types of cases being brought against companies that have been hacked by third-party hackers. So we could go to the next slide, please. In parallel with that, and I'll get into the cases in just a sec, we have settlements. So since 2021, 10 settlements in the privacy class actions approved. Happy to provide any additional details about these cases for anybody who's interested. 7 of those over 1.6 million, many are much higher than that. 0 to 3,000 per class member on a per person basis in these cases in terms of what people get. The $0 is a case where there's a payment to charitable organizations or public service organizations that are benefiting privacy interest issues, that sort of thing. Plaintiff counsel typically paid 20% or more of the settlement amounts, so that will tell you these cases will still continue to be brought because they are getting paid out to the plaintiff counsel. We could go to the next slide. Very significant decision in which we are counsel for Equifax in this case, 2022 case many may have heard of. The Court of Appeal in Ontario, for the first time in an appellate decision in Canada, rejected the intrusion claim against a hacked organization. So the court said, look, a failure to prevent an intrusion by a third-party hacker is not an intrusion upon seclusion, and Equifax cannot be held liable for intrusion upon seclusion. For different reasons, and other remedies were available. Could go to the next slide. Very important decision. 2 other decisions released at the same time, the Winder and Marriott and Obido and TransUnion, for different reasons, came to the same conclusion. They had some additional issues in these cases. Otherwise, they applied the Equifax reasoning, but in essence, they concluded there was no vicarious liability for the action of a hacker, understandably, and there was no allegation that was capable of being an intrusion just for collecting the information. So you go to the next slide. Rouge Valley, a case where there was really not very sensitive information involved in that case. So in that case, there was no intrusion available against the defendant. We could go to the next slide. And Stewart and Dem, again, similar. Access was fleeting really to get access to drugs. The defendant was not after the personal information in this case, and therefore intrusion was also not available in that case. So we have a handful of cases, about a half dozen released in the last year, that have closed the door on the intrusion claims. And we could go to the next slide. And with that, I hand it to Darren.
Thanks, Alex. Good morning and good afternoon, everyone. I'll try to address these 2 decisions in about 3 minutes, so bear with me as we go through this. So the Setaguchi and Uber case, you can go to the next slide, are 2 decisions, the first arising from the Alberta Court of King's Bench and the second from the Alberta Court of Appeal. What's interesting about the case is that it shows a general recalcitrance of the courts in Alberta to certify data breach class actions, where the information accessed or taken is not private personal information and where there's no provable post-breach losses. And that weighed large in the minds of both the lower court and the Court of Appeal when they dismissed certification of this proposed class proceeding. In relation to the facts of the case, what's not mentioned here as well, but what does figure in the decisions of the courts, is the breach wasn't made public. At first, it was discovered and later made public, but there had been no incidences reported, at least in evidence before the court, that there had been any knock-on fraud or any other losses that had occurred as a result of the breach. Next slide, please. So, interestingly, amongst a bunch of other causes of action that had been alleged, the claimants sued Uber in breach of contract and negligence. And the breach of contract claim had 2 branches. First, that the contract had been breached by storing data on the cloud without consent. Secondly, a failure to notify Uber customers of the breach. The negligence claim was what I'd call a traditional negligence claim, except the loss complained of, so the harm that was alleged and damage that was alleged, was based on a first loss theory, which really has no support in law, and there was no evidence before the court that any other court anywhere had found that there was some kind of nominal or set amount of damage that could be paid to an individual where their information had been accessed or taken without proof of actual loss. Next slide, please. So at certification, the Chambers judge's decision is quite interesting. The court goes on at length about the strictures under the decision-making process under Section 51A of Alberta's Class Proceedings Act, which in essence only permits the court to look at what is drafted in the statement of claim to assess whether or not there are viable causes of action pled. After a bit of a tortured analysis, the court decided that it couldn't deny certification on the basis of the face of the pleadings, and then goes on in the decision to deny certification on the preferability grounds. What happens next is the Court of Appeal gets a hold of the decision, and they changed some of the reasoning of the Chambers judge, which is a bit winding, and they did deny certification. What they said was that the negligence claim, sorry, I forgot to say next slide. If you could go to skip ahead one more slide, please. And the next one, thank you. What they did say was that on the face of the pleading, the negligence claim failed because it didn't plead any damages that were known at law, and the court refused to recognize the novel claim of the first loss theory as something that would pass muster under the Section 51A test. For the remainder of the Section 5 analysis, the Court of Appeal then dismissed the certification application on the basis that the only remaining cause of action that the Court of Appeal had before it was the narrow contractual claim for the failure to warn of the breach, which it appears as though nominal damages were pleaded. And the Court of Appeal went through an analysis and found that the class action or class proceeding wasn't the preferable process. So interesting case. There's a lot of interesting reasoning in both decisions. And I've been told, but I'm not sure whether or not it's happened by counsel involved in the case, that there are leave applications that may be filed. So we'll see if the Supreme Court does anything with this case. Thank you.
Thanks, Darren. I should add, in the Equifax and the Winder and Marriott and the TransUnion case, leave has been sought to the Supreme Court of Canada in those decisions. So we'll wait to see what the Supreme Court of Canada does with that. With that, we hand over to Daniel and William.
Thank you very much. We're going to spend a few minutes talking about some notable and recent Federal Privacy Commissioner investigations. And I'm going to start off by talking about the Home Depot decision. At the end of January, the Privacy Commissioner of Canada released its investigation report following a complaint about Home Depot. And the customer of Home Depot complained that the retailer had disclosed their personal information to Meta, so the operator of Facebook, and specifically that the disclosure was about his in-store purchases as well as his email address. Now, he discovered the disclosure through Facebook's privacy settings, which identify what personal information had been received by Facebook from external sources. Basically, this is what was happening. If you were a Home Depot customer shopping at a brick and mortar store, you'd go to the cash register, you'd pay for your purchases just like normal, but at screens at the point of sale, you'd have the option to have your receipt emailed to you. And if you wanted to do that, then you'd be prompted to type in your email address for that purpose. Now, this wasn't the impugned activity. Like many retailers, Home Depot sought to measure the success of its social media advertising. And it did this by disclosing customer transactions, in-store transactions, plus customer email addresses to Meta for analytics. So basically a report about whether the customers who actually bought stuff in the store were presented with relevant advertising on Facebook in the time leading up to the in-store purchase. Of course, this only works if the customer used an email address for the e-receipt that is associated with their Facebook account. But in any event, measuring the success of advertising in this way is called offline conversions, and it really gives companies quite useful insights on the success of their advertising campaigns and the dollars they spend underlying those campaigns. And it's a fairly prevalent practice among retailers. Now, it's also possible for social media platforms to create lookalike audiences. So based on the offline conversions, what sort of customer might also be interested and who might resemble the customers of the given retailer. And so that can also further advertising on these platforms. So here, the individual complained that they'd not been informed of the disclosure to Meta and they'd not consented to it. And the report revealed, of course, that the privacy commissioner agreed with the complaint. Now, the retailer raised several arguments to defend its practice, and we don't have a lot of time, so I won't get into them in any detail. But the gist is that the commissioner found that relying on an implied consent model was not appropriate. Primarily, this was because customers were not presented with the privacy policy at checkout. In fact, some of the customers in store may have never visited the retailer's website where the privacy policy was displayed. And so it couldn't be argued that this practice was within the reasonable expectations of these customers because it appeared in some privacy policy that was at some remove. And so given that factual nexus, the commissioner saw express consent as proper, meaning the individuals would have to check a box on that screen saying, yes, I'm fine with this being used for this other purpose. The commissioner also disagreed with the characterization of Meta as a service provider because in the commissioner's eyes, it appeared that Meta was making independent use of the information to augment its own analytical capabilities. And so ultimately the commissioner said, look, in these facts, an implied consent model that Home Depot is using wouldn't work. Now, the report is nuanced. Some commentators in reading the decision have taken it to mean that measuring offline conversions in this way now always requires express consent. And to my mind, that is an overly restrictive reading of the decision. In the decision, the commissioner took care to focus the report and the decisions on the specific facts of this case, which is mainly the weak link between the transaction and the privacy policy and how the privacy policy framed the sort of offline conversion activity that was going on. There is an instance in the decision, it's some obiter dicta in my view, if that term can apply to a commissioner decision, where the commissioner floats a concern, a generalized concern, that maybe social media platforms, given how much information they hold about individuals, can take non-sensitive information and give it a sensitive cast, that any information you give to a social media platform can be seen as sensitive. But this comment is made, at least in my view, in a brief aside. It is not developed beyond the offhand comment. It is not stated as part of the basis for the decision. So to my mind, the Home Depot decision does not upset prior commissioner guidance on when implied consent is viable. And so other retailers, other organizations that are using or want to use social media platforms in this way may actually be in different circumstances from Home Depot and may be able to ground their activities in an implied consent model. And it really comes down to assessing the facts of each organization's circumstance. To the extent it's helpful, to my mind, a strong basis for arguing implied consent for this sort of activity under PIPEDA would involve the following elements. It would involve that the customer was presented with the privacy policy in some connection with the transaction, that the policy adequately describes the information sharing with the social media platform and the associated uses by the platform, that the disclosed information is non-sensitive, of course, and that the customer has the ability to opt out of the information sharing. And ideally, the privacy policy would explain, all right, here's how, as an individual, you can opt out if you don't like this sharing. Now, of course, this commentary is specific to PIPEDA, and it's specific to Federal Privacy Commission of Guidance for companies that operate in Quebec. Act 25 will introduce some interesting notions around profiling technologies and the like. But in terms of the Home Depot decision itself, I think it's important to read it in light of Home Depot's facts and to consider, if you're a retailer that engages in this practice, to consider your own activities and how you might engage in social media marketing and in offline conversion measurement. So I'll now turn it over to William for a few words about TikTok and OpenAI investigations that are in progress.
Thanks so much. Hi, everyone. Yes, this is very interesting in terms of applying the consent transparency principles to online advertising. On my part, I'm going to talk very quickly about two active investigations that were launched recently. So those are active. There is no report on that on which we can talk today, but still two very interesting investigations that have been launched in the couple last months. By the Office of the Privacy Commission of Canada, but jointly with the other Canadian privacy authorities from Alberta, Quebec, and British Columbia. The first one is concerning the TikTok app, and the second one is on the OpenAI's now famous artificial intelligence-based chatbot. I don't think these two platforms need any further presentation, so we're going to focus on the key points to watch out regarding those investigations, according to what has been announced so far and what we think we can expect from those cases. Yes, we have limited information to date because yes, those investigations are active, but those will be particularly interesting as for the Home Depot case on the application of central principle of consent to highly popular and emerging tech commodities. So the first one is the rise of social media focused on, yes, algorithm-based video content streaming used by an important portion of younger users. So that's a specific issue here. And on the second case regarding OpenAI, in relation to the development, training, and offering of a highly advanced conversational AI product used directly by consumers in many cases. As I mentioned, both investigations will be jointly conducted by the privacy authorities in Canada, so from the provinces and at the federal level. It's an approach that we see more and more often, not only for cross-jurisdictional impact, optimizing resources, sharing knowledge and expertise, but also harmonizing Canadian law and ensuring consistency. So more specifically regarding the TikTok investigation, very quickly, it was announced on February 23, 2023, that those authorities would jointly investigate the application. In their joint announcement, the 4 privacy regulators indicated that they intend to examine in particular whether a valid and meaningful consent is obtained for the processing of personal information, with a focus on how consent is obtained to process information about younger users. They'll also take a look specifically, according to the announcement, to the transparency obligations of TikTok. Finally, regarding more specifically the ChatGPT case, it was first announced on April 4, 2023 by the federal commissioner following a complaint alleging the collection, use, and disclosure of personal information without consent. And then on May 25, 2023, it was announced that the provincial authorities joined the investigation. Given the broad, and I quote, given the broad scope and significant privacy impact of AI and its relevance to all Canadians. So two key investigations to follow and to keep an eye on for the OpenAI. Key issues to be investigated according to the announcement. They're going to take a look specifically at the valid consent, transparency principle, legitimate purposes, and limiting collection. So let's say that the privacy commissioner, Philippe Dufresne, has been clear in the last months saying that artificial intelligence and its effect on privacy are a top priority for the Canadian commissioner. And he said that his office must stay ahead of fast-moving technological advances. So let's keep an eye on these ones, and hopefully we'll have more interesting stuff to say about it or for our next webinar. Thank you very much. I'll hand it over to my colleagues now, Kateri-Anne Grenier and Yara Griffith.
Thanks, William. Hi, everyone.
Yara, I wanted to make a proper introduction to your first case, the AB versus Google, a recent decision by the Quebec Superior Court released on March 28th. It is to be noted, however, that Google has filed an appeal on May 2nd. And I think it's interesting because it's one of the first decisions to interpret Section 22 of the Act respecting the legal framework for information technology and to apply it to an intermediary like Google that provides referral services and search tools. And my understanding is that the court found Google liable and awarded damages to the plaintiff in the amount of $500,000. plus an injunction order. So let's talk about what were the facts and why this case is interesting.
Thanks so much, Kateri. So I'm going to start with the facts and touch on the decision that ensued. So our story begins with a man, the plaintiff, who woke up one day to find himself accused of a serious crime he did not commit. So the plaintiff was a respected businessman in the public and private sectors, but in 2006, a defamatory publication falsely accused him of running a fraudulent business and being convicted of pedophilia in 1984. This publication appeared in Google search results when the plaintiff Googled his name. So the plaintiff asked Google to remove it, which was done, but then undone, and plaintiff eventually filed a lawsuit. So as you mentioned, Kateri, the court awarded damages for moral prejudice in the amount of $500,000 and required through an injunction that the defendant remove the defamatory content from search results for Quebec users. So, Kateri, I want to briefly explore the court's reasoning for this decision. So, with regards to applicable law and jurisdiction, the court determined that Quebec law applied to the case, given that the plaintiff lived in Quebec and that the harm had occurred there. And as you said, the court also analyzed the IT Framework Act and concluded that Google's liability for defamation in Quebec fell within the purview of this statute. So the IT Framework Act, which is not that often invoked, is a specific Quebec statute that governs, among other things, the liability of internet intermediaries such as web search engines. And under this act, an intermediary providing a research platform is generally not responsible for the activities of its users. However, if the intermediary becomes aware that its services are being used for an illicit activity, such as the dissemination of defamatory content, is required to act promptly to cease providing services to the individuals engaged in such activities. As such, it's an exception that provides for liability for defamation where the intermediary has been given notice of defamatory content. And in this case, the court found Google liable for making the defamatory content available in its search results because Google had been informed of the unlawful nature of the content but failed to act promptly, thus committing a fault.
Excellent, very interesting. Thank you so much, Yara. And now I want to hear you talk about the Charest versus Quebec ruling that was issued on April 4th by the Quebec Superior Court. So this is, of course, a lawsuit that was filed by former Premier of Quebec, Jean Charest, against the Quebec government following media leaks of personal information related to ongoing investigations. And, you know, many things in this judgment are interesting. The Quebec government announced it would not appeal the conclusions of the Superior Court. And really one of the many interesting aspects is the record amount of punitive damages that was awarded. And those punitive damages were not awarded based on the Charter of Freedom, of Right to Freedom, but on Section 167 of the Quebec Access to Information Act. So that never happens. So tell us a bit more in details about this case.
Absolutely. Thanks, Kateri. So let's start with the facts. So the plaintiff, who was the Premier of Quebec at the time, Jean Charest, initiated the Commission of Inquiry into the awarding and management of public contracts in the construction industry, also known as the Charbonneau Commission. And in parallel, the Unité Permanente Anticorruption, a police unit, was created to investigate corruption in the construction industry based on the Commission's findings. So, as illustrated in the slide, the Liberal Party created UPAC, and UPAC investigated into the Premier of Quebec's role into corruption, and as part of its investigation, chose to leak confidential documents to renowned media in Quebec. And these documents contain the plaintiff's personal information, including surveillance details, private communications, and even his photo on a chart titled Illegal Political Financing. So the leak raised important concerns about privacy, and also we should note that the plaintiff was never convicted or accused of any ties with corruption in this case. So as Kateri, you mentioned, under Quebec's Access Act, UPAC and the government has an obligation to protect the personal information it holds as a public body, and no exception to consent allowed for the disclosure of the plaintiff's personal information to media. And the case also shown that this leak wasn't an isolated case. There were over 54 leaks of information to the media. So in this case, the court recognized the harm caused by the unlawful infringement and awarded compensatory damages to the plaintiff in the amount of $35,000. But as you said, the most remarkable aspect of this case was the awarding of punitive damages. So while the claim based on the Charter of Human Rights and Freedoms was dismissed because under the Charter, you can only impose punitive damages onto the author of the violation, the court invoked the Access Act, so Section 167 of the Access Act, to grant punitive damages, whose provision on punitive damages is more broadly drafted. So the court deemed the disclosure intentional on the part of the UPAC employee who had leaked it, and a result of gross negligence. So it emphasized on the need to prevent and deter, and imposed a very, very high amount for punitive damages for a total of $350,000. And Kateri, I don't know if we mentioned, but the court also allowed the plaintiff to amend its proceedings to file a separate lawsuit for abusive proceedings.
Yeah, exactly. That will be going on in the next months. I want to close this segment by talking about the Facebook or Meta recent federal court decision involving the Federal Privacy Commissioner. This was released on April 13, 2023. An appeal was filed by the Privacy Commissioner on May 12 before the Federal Court of Appeal. And in brief, the federal court dismissed the commissioner's application in its entirety with cause, so we will find out why. This was a federal privacy commissioner's application to the federal court under the powers awarded by Section 15 of PIPEDA. Of course, this is a Cambridge Analysis-related matter. So following an investigation by the commissioner back in 2019 of a privacy complaint, the privacy complaint was that a third-party application known as This Is Your Digital Life, TYDL app, hosted on the Facebook platform, had sold Facebook user data to the British research firm Cambridge Analytica, who afterwards transferred it to a related firm, SCL Elections. It was afterwards widely reported that SCL had used that data to help its clients target political messages to potential voters in the context of the 2016 US presidential election primaries. So the app allowed access. When you installed the app as a Facebook member, the app allowed the access to the profile information of users who installed it, as well as the installing users' Facebook friends. So this situation allowed the app to collect the data of over 600,000 Canadians. In February 2020, the Federal Privacy Commissioner attempted to enforce its office's finding that Facebook violated PIPEDA by filing the application with the federal court and seeking orders. There were a number of legal issues discussed before the court, but we believe that these two are the key questions that are the most relevant. The first question was, did Facebook obtain meaningful consent from its users and Facebook friends users prior to sharing their personal information with the app? And also, did Facebook adequately safeguard user information? On the issue of consent, the court held that Facebook could rely on third-party consent on the condition that it must take reasonable steps to ensure that the third party obtains meaningful consent. And reasonable effort here is the criteria in PIPEDA. Also, something very specific to this case is that the court held that it faced an evidentiary vacuum, meaning that the commissioner had failed to discharge his burden on this issue. It is our understanding that several pre-trial debates took place on this topic of admissible evidence, and that Meta was successful in obtaining orders striking evidence led by the commissioner, therefore greatly limiting the evidence that the commissioner could use in court. So the court also mentioned that it was somehow surprising that the commissioner did not use the broad powers he has to force the disclosure of evidence. And this is also a reminder that the proceedings introduced under Section 15 of PIPEDA are a de novo trial. So the court will only rely on the evidence presented, and no deference is given to the prior commissioner's investigation and its finding. And by the way, Bill C-27 could change that, because it would introduce a new enforcement regime and a new level of exposure to penalties for non-compliance, and also give deference to commissioner's findings. On the last issue of adequately safeguarding user information, Facebook argued that its safeguarding obligation ended once a user authorized Facebook to disclose information to the third-party app. And the court agreed. In making its finding, the court cited the difference between transferring information to a third-party provider, in which case the organization remains in control of the information and accountable for its safeguard, versus the situation of disclosing information to a third party with the prior consent from the concerned individual. So that was a very important distinction. I will now hand it over to my colleagues, Christopher Ferguson, Justin Pong, and Summer Lewis, who will talk about artificial intelligence.
Thank you, Kateri-Anne. So just a quick rundown of what we'll talk about. I'll start off with developments in Canada. Justin will contrast those with efforts in the EU. And Summer will finish off by discussing how existing laws are being adapted and applied with AI. And just a quick note, we're discussing laws of other jurisdictions, but we're all Canadian lawyers here. So this is a transition slide, just saying what generative AI thinks of lawyers and government regulating AI and what that would look like. It's pretty dark. So first thing we'll talk about is the automated decision provisions in the Consumer Privacy Protection Act, or CPPA, and Bill C-27, which would be a reform of federal privacy law. Now, the definition of automated decision systems in the proposed act is extremely broad. It includes any systems that assist human decision-making and not just replace it, but it also includes machine learning, other statistical techniques, which are things you'd expect, but also includes rules-based systems, which could capture things like normal computer programs that are not necessarily AI or machine learning, and as well as like flowcharts and decision trees. So it's a very broad definition. Now, the proposed automated decision systems provisions in the CPPA would apply to systems that are used to make predictions, recommendations, or decisions that have a significant impact on individuals. Now, significant impact is not defined in the CPPA and is not a particularly precise term, but given the relatively limited obligations in the proposed CPA, you do expect organizations to be fairly conservative in interpreting what that means. So what are those obligations? Well, first is to give a general account of systems that can have a significant impact on individuals in an organization's public privacy statements. And then secondly, on the request of an individual, explain in relation to those systems that can have a significant impact the type of personal information used to make the prediction, recommendation, or decision, the source of that information, and the principal factors that led to prediction, recommendation, or decision. So relatively limited obligations, at least in this iteration. Next slide, please. A couple of quick distinctions with the revised Quebec Act. Won't go into depth in them, but it's interesting to note that the Quebec Act is engaged when automated processing is used exclusively to render a decision, so not just assist as in the CPPA. There's obligations with respect to disclosing that automated decisions at the time of the decision. And also individuals must be able to submit observations to someone who is able to review the decision, which is not in the proposed CPPA. Next slide, please. So now we'll move on to the Artificial Intelligence and Data Act, which is the AI-specific component of Bill C-27. Now, this was a bit of an unexpected component of Bill C-27, which was introduced in June 2022. And it's really seen sort of a second wind with the rise of generative AI and the debate on the regulation of AI systems that happened in the wake of that. So what does ADA regulate? Well, it regulates the designing, developing, and making available of an AI system or managing its operation, as well as the processing or making available for use any data relating to human activities for the purposes of designing, developing, or using an AI system. Now, it's important to note that what we're discussing and trying to elaborate on it, ADA is really framework legislation and leaves important concepts to be determined in regulations later. Specifically, the definition of high-impact AI systems, to which a lot of the most onerous obligations of ADA would attach, is to be determined in regulations at a later time, as well as the amount of penalties that can be assessed under ADA. Now, the ministry responsible for Bill C-27, ICED, has released a companion document since for ADA where it says it expects the process of rulemaking to take 2 years. So ADA would not come into force, even if it came into force this year. I'm sorry, if it were passed this year, it would only come into force at 2025 at the earliest. Next slide, please. Now, what is the definition of AI systems under ADA? Well, ADA defines an artificial intelligence system as a technological system that autonomously or partly autonomously processes data related to human activity through the use of genetic algorithm, a neural network, machine learning, or other technique, and is used to generate content, make decisions, recommendations, or predictions. A couple of interesting things there. One is that the data must relate to human activity, which is sort of an unclear but introduces an interesting limitation. And then finally, like with the CPPA, you have the introduction of this catch-all, another technique, which could really be any data processing technique. Next slide, please. So in its companion paper, ICED released some factors which would go into the definition or go into considering whether an AI system is a high impact system. And some of those are what you'd expect. For example, the severity of the harm of the system, the scale of use of the system, the ability to opt out of its use, et cetera. But one interesting factor is that ICED included whether other legislation applies as a consideration, suggesting that regulatory gaps could be a factor in whether a system is a high impact system, which makes sense if when we get to summer about the application of existing laws to AI systems. Next slide, please. So finally, a quick rundown of what ADA's obligations would be. So those would be measures with respect to the creation, use of anonymized data, assessments for whether an AI system is a high impact system, risk management for high impact systems, as well as transparency obligations for high impact systems, and finally, notifications to the minister for material harm or likely material harm that results from the use of a high impact system. This is a very, very quick rundown, but we've got a lot to talk about today. And with that, I'll turn it over to Justin to talk about AI regulation in the EU.
All right, thanks very much, Chris. So now that Chris has covered off regulatory developments on AI in Canada, I'd like to spend just a few minutes talking about similar events going on right now in the European Union, which is where we may actually see the first comprehensive regulatory framework for AI take effect. And I'm specifically referring to the proposed Artificial Intelligence Act, which I'll refer to as the EU AI Act for the next few minutes. The AI Act in the EU was actually proposed over 2 years ago in April of 2021 by the European Commission, which is part of the executive branch of the EU. It's one of 3 main legislative branches there, along with the European Council and the European Parliament. And that background will become relevant as I talk about the update on current negotiations over the AI Act. In its current form, the AI Act sets out pretty comprehensive rules for how AI is developed, provided, and used in the EU. And in contrast to the proposed principles-based approach under ADA in Canada, the EU AI Act would actually take a risk-based approach. And I should mention also that the draft law in the EU is constantly evolving. The different legislative branches of the EU that I just referenced are proposing their own versions for their internal negotiation process. And so we may see potentially significant changes to these concepts and the definitions. So for now, I'm just going to focus on the key aspects of the EU AI Act that have emerged in common from these different positions. In terms of the scope of the EU AI Act, the definition of AI is currently under debate between these 3 branches. The original proposed definition was software that is developed with one or more techniques and approaches specified in the legislation, such as machine learning, and which can, for a given set of human-defined objectives, generate output such as content, predictions, recommendations, etc. There is some concern that the definition initially proposed is overbroad, and so the three branches are going back and forth right now in terms of narrowing and refining that definition. The scope of the act would apply quite broadly. It would include AI deployers located in the EU, providers who make AI services available in the EU, regardless of the location, and both providers and deployers of AI systems whose outputs are intended to be used in the EU. And so, similar to what we see with the EU General Data Protection Regulation, the extraterritorial impact of the AI Act is potentially going to be quite broad and potentially have a lot of influence on how AI regulation develops in Canada. The EU AI Act classifies AI systems into 4 classes based on their level of risk. So first, we have AI systems with unacceptable risk, such as using it for social scoring, assessing someone's trustworthiness based on their social behavior, biometric identification by law enforcement. Those systems would be categorically prohibited. So completely blacklisted and not permitted under the AI Act. Second class is AI systems with high risk, which would be permitted subject to compliance with several risk management requirements, such as conformity of assessment, registration with the EU, ensuring effective human oversight. And those kinds of high-risk AI uses would include its application in areas such as life insurance and health insurance. The third class is AI systems with transparency risks, and that includes AI systems involving emotion recognition or impersonation/deception. Those, again, would be permitted subject to meeting certain transparency obligations, such as notifying individuals that they are interacting with an AI system. And the fourth and final class would be AI systems with minimal or no risk, and those would be permitted with no restrictions. As you can imagine, these classes and the systems that they pertain to are being debated between the 3 branches right now, so we should expect to see some changes in the final list that does eventually emerge. In terms of how the AI Act would be enforced, the current proposal would allow for fines of up to 30 million euros, or in the case of companies, up to 6% of total global annual turnover based on the preceding financial year. So we are looking at pretty significant financial penalties, potentially. And in terms of who enforces this, currently under debate is whether you enforce it through existing data protection authorities or a new centralized agency, so AI-specific regulators. The AI Act currently is, as I mentioned, being debated between the European Commission, the European Council, and the European Parliament. The next stage we're expecting is to see the EU Parliament finalize its own version, which is actually expected sometime this month. And once they do, that will kick off the official trilogue process in which the 3 institutions will negotiate over the respective versions and pursue a final version to become law. I'll just very quickly note that in terms of what existing laws in the EU would cover AI right now, we do see provisions under the GDPR that do regulate automated decision-making. So similarly, or rather not similarly, but specific to the GDPR, this actually gives individuals the right not to be subject to solely automated decision-making with legal or similarly significant effects on individuals. And it gives those individuals the right to obtain confirmation of the use of such automated decision-making and a right to an explanation of the underlying process. So that applies pretty narrowly to a potential use of AI systems, and the EU AI Act would go much further than that in establishing a fairly comprehensive regulatory framework. So that covers off regulatory developments on AI in the EU, and with that, I'll turn things over to my colleague, Summer Lewis.
Thanks so much, Justin. So I'll wrap up our chat on AI by talking a bit about developments in the US, and then we'll wrap up with a few interesting points on sectors in Canada that have sort of been thinking about AI regulation, but we don't have anything really concrete yet. So to start in the US, at the federal level, there's nothing concrete like we've seen from from Justin and Chris in their presentations on Canada and the EU. The White House is very much in the exploratory phase. The most recent announcement from the White House, from their Office of Science and Technology Policy, is actually a request for information, which asks the public for submissions on a variety of topics. Some of the questions, it's actually quite a lengthy list, include how AI could be used to innovate in public services, how it could be used to promote economic growth, and then in addition to measures like mitigating algorithmic discrimination. So in California, we have a bit more progress. You'll see from federal to New York, we get a bit more concrete. So stay with me, it gets exciting. So in California, the Privacy Protection Agency basically has the authority to make regulations under the California Privacy Rights Act of 2020. So essentially, in the last few months, they solicited preliminary written comments from the public regarding proposed rulemaking, and it was on 3 topics which the California Privacy Rights Act gives them the authority to make regulations for. So that's cybersecurity audits, risk assessments, and then automated decision-making. So that language should probably sound familiar to you based on what Chris and Justin have been discussing. So essentially, the comments have been published, and the agency is in the feedback stage where they're looking to navigate, how to balance feedback from various stakeholders. So there are some industry requests for more flexible, some requesting fewer requirements. That's arguable, I suppose. And then the concerns of privacy advocates regarding the impact of automated decision-making tools in areas like employment, housing, or health. Again, themes that Chris and Justin have been talking about as areas where people may have concerns about adding extra protections where AI tools may be used. And then the last example in the US is coming from New York. So New York is actually one of the jurisdictions that's honed in on the impact of AI in employment. So the city adopted final regulations on the use of, it's called automated employment decision tools. So we'll call them AEDTs. And it's specifically limited to hiring and promotion decisions. So employers have until July 5th, 2023 to determine whether they use an AEDT to make decisions about hiring and promotion. So AEDTs, I know we're probably tight on time, so I have the definition up on the screen for us. You'll see it's pretty broad, and the definition not included on the slide sort of carves out anything that's not an automated employment decision tool. So anything that's like a database with employee information, anything that's like a firewall, antivirus software for security. There's actually a pretty good list of exclusions, so it makes it clear what's not included in those types of automated decision-making tools. But the important part for employers to know is that if you, based on this definition, decide that AEDTs are used for hiring and promotion, you have to conduct a bias audit with an independent auditor. Then you need to publish the results of the audit, and it has to be in a clear and conspicuous manner, like on the employer's website. And then notice also has to be given to the affected parties. So that could be a candidate, for example. One of the examples the regulation gives is including it in a job post. Or for employees, you may include it in a written policy or procedure. And then if we move on to the next slide, I'll just touch very quickly on a few areas in Canada where there's been sector-specific interest in regulating AI. So an exciting one is in respect of the financial services industry. So the Office of the Superintendent of Financial Institutions and the Global Risk Institute basically partnered to create this community of AI thought leaders, and it's called the Financial Industry Forum on AI. So essentially the forum discussions around AI led to the development of the EDGE principles. So that's explainability. Again, I don't want to be too repetitive, but essentially that boils down to whether an individual can understand how an AI model arrives at its final conclusion. And then data, thinking about how a financial institution could leverage data to create targeted or tailored products and services, or how it could use it for fraud detection, for example. That would be a bit more unique to the financial institutions. Governance, so ensuring that there's a framework that promotes responsibility, accountability of an organization that's using AI tools, and then ethics. So thinking about the broader societal impacts of the AI tools that the organizations are using. So interestingly, the outcome of those conversations, aside from having these guiding principles now, which can likely very much guide any guidance documents or regulations that may come out of OSFI's work with this forum, it also resulted in a synthesized report. So that surely will serve as an important resource that highlights all of these stakeholders' inputs. I don't think I mentioned, but the membership of the forum included not just regulators, but banks, insurers, pension plans, fintech. So there are a broad array of opinions that were included in those conversations. And the last thing I'll highlight, there's no formal regulation or practical tool that came out of this, but it's quite interesting that there's a joint statement released by the Information and Privacy Commissioner of Ontario and the Ontario Human Rights Commission on the use of AI technologies. So essentially both bodies recognize the overlap in their work, committed to collaborating on helping Ontarians better understand their privacy rights in relation to AI technologies, but then also called out the Ontario government and has sort of urged them to move past the draft principles that they had published in 2021 and establish some more binding and granular rules that would govern the public sector's use of AI technologies. So as you can tell, across jurisdictions, there's sort of a patchwork right now. I don't know if any one of us have given you a very clear, delineated line of resources that you can go to, but hopefully it helps you orient yourself and understand recent developments related to AI technologies a little bit more. So I'll pass the mic on to my colleagues who will be discussing provincial privacy updates and privacy impact assessments. Thank you.
Thank you very much, Summer. So my name is Andrew Dixon, and I'm a part of the privacy team here in Calgary. We're going to be talking a little bit, along with my colleagues Zuleika Munier and Rachel Schechter, about some updates to privacy impact assessments in Canada, specifically in Quebec and in BC, for you to be aware of. So the first thing to review is just a quick background of what exactly is a privacy impact assessment for those individuals who haven't had to do one. And essentially, it's a risk management process. It's a review of a program or activity or undertaking that involves personal information, and it's an attempt to try to figure out proactively what the potential impacts are of that program or undertaking on an individual's privacy, and how does that practice comply with legislative requirements as well as best practices. Next slide. So the big question then is why is it important to carry out a privacy impact assessment? And the first part is that it's required under a number of different legislative regimes. It's required federally under PIPEDA. It's coming into effect and going to be required in Quebec, which my colleague Zuleika is going to talk to you about. There's been new changes in British Columbia to make it required under FOIPA, and it's required in Alberta under the Health Information Act if you're a custodian in handling health information. And in addition to that, some service providers are finding out that it's becoming part of their contractual requirements with their clients. We're seeing more and more that certain clients are requiring privacy impact assessments as a contractual requirement when they're retaining different service providers. And as you can see on the slides, it does have a number of benefits. Specifically, it reduces the risk of improper, unauthorized collection, use, or disclosure of personal information, which is specifically important in those jurisdictions that require mandatory reporting for privacy breaches, such as Alberta. In addition, it allows you to incorporate best practices proactively so that you can find out if there's any weaknesses or deficiencies with the process before it becomes an issue. And that helps because you're able to make decisions on how to implement processes that work with your business needs in advance before you find out whether or not there's a problem. And in doing so, you're also able to build trust with your clients, with your customers, to know that the information is being handled not just in accordance with legislative requirements, but also that you're looking out for the personal information and you're improving your trust with the people you're interacting with. And so with that, I'm going to turn it over to Zuleika, who's going to talk about the process for how to carry out a privacy impact assessment and some of the changes to look out for in Quebec.
Thank you, Andrew. So now a question that we're often asked, how is a PIA carried out in practice? There are multiple actions that we can regroup as schematized on the slide that you are seeing on your screens. Before starting, the first and the most difficult step is to identify the need for a PIA. To do so, you need to raise awareness across your teams and train them to identify those situations in addition to their usual day-to-day responsibilities. Again, to do so, you need to ask yourself, how can I insert this process into existing processes? Think about your project management documents or your existing governance procedures and policies. If using those documents isn't possible in your situation, either because you don't have any or because it is not appropriate in the circumstances, you'll need to create new processes within your internal policies regarding the protection of personal information, which, by the way, will be mandatory as of September 2023 in Quebec. So for the two phases that you are seeing on your screens, once your teams are fully trained and able to identify situations requiring a PIA, you'll need to build templates. These templates should be divided into two sections, which must be completed by different stakeholders. The first phase is completed by the project manager and its team, while the second one is completed by the privacy officer and its team, or if you're a public body, by the Committee on Access to Information and Protection of Personal Information. This is important as the full PIA does not need to be disclosed throughout the organization as it can contain privileged or confidential information. Only useful information, meaning the decision and the recommendations, if any, should be disclosed outside of legal. And lastly, the decision-making step. So the decision must be made in accordance with organizations' policies and practices, and of course, applicable laws. For example, privacy officer may refer to the CEO, so the highest authority, before refusing certain project or authorizing some others with great sensitivity. And a PIA is an evolving analysis, of course. It must be continually updated on the initiative of the privacy officer or the project manager when a change in the project requires it. For example, a request for proposal, an RFP, should certainly be updated when the RFP is created, when the choice of bidder is made, and when the implementation of the chosen system starts. All documents must be preserved at each phase, for example, using addendums. So next slide. What are the requirements? Well, they change throughout Canada, but as you must now be aware, Quebec has adopted its own rules for the public and private sectors, requiring organizations to conduct PIAs in three main situations shown on this slide. The first one is the implementation of IT projects or a substantial change to an IT project. The second one is the communication of personal information outside of Quebec. And the last one is the communication of personal information in the context of a research project. So for instance, this could touch the pharmaceutical industry or universities or research centers. And as the study criteria for each situation vary in the Act, depending on the volume of PIA you will have to carry out, you will need to use different templates. So now passing along to Ashley, who will present the situation in BC.
Hi, everyone. So the view from British Columbia, in late 2021, our Freedom of Information and Protection of Privacy Act was amended. This is our public sector legislation. And amongst the significant amendments that relate to PIAs was the removal of a data residency requirement, where public bodies are now permitted to store data outside of Canada in circumstances where a PIA has been performed. Ministerial directions issued at the same time clarifies that public bodies must conduct a PIA on any new initiative on which a PIA hasn't been previously conducted, and before implementing a change to an existing initiative, including changes of location of storage of data. Additionally, further amendments came into force in 2023, earlier this year. This includes requirements for a privacy management program by public bodies, as well as the introduction of mandatory breach reporting. In terms of what this sort of suggests for private sector developments, we remain eager to see amendments to our private sector PIPA legislation, but the changes to FIPA may indicate changes to come in the private sector. Privacy impact assessments remain, recommended best practice from the OPC, and so we will be interested to see if the legislature ultimately takes up some of the special committee's recommendations, which were issued in late 2021. Which included the requirement, an introduction of a requirement for PIAs to be performed in relation to sensitive data. And that's generally consistent with sort of trends nationally and globally, increasing an emphasis on PIAs. When those laws will be amended, Time will tell, hopefully by the time of the next webinar. But certainly we expect that mandatory breach reporting may come to the private sector, as I believe we're the last outlier at this point. And with the topic of breach reporting requirements, I can hand things over now to my colleagues, Naresh and Daanish, who will talk about that.
Thanks very much, Rachel. So yeah, Nareg and I are going to speak to dealing with breach obligations briefly. Next slide, please. We'll start first by talking about some trends related to ransomware, which is one of the more common types of cyber incidents that we see in our practice that results in breach obligations being triggered. So for those who are not aware, ransomware is a virus that encrypts files so that it's unusable unless it's decrypted. A hacker then demands a ransom in exchange for a tool that decrypts the files. It's one of the more severe types of cyber incidents we see, given the potential for operational impact. However, since late 2018 and early 2019, hackers that spread ransomware have started an additional method to extort money from organizations. Namely, in addition to spreading the virus, they would also make copies of the organization's data and threaten to post it on the internet if they're not paid a ransom. This is referred to as the double extortion model. As a result of this double extortion model, and for other reasons, ransom demands and amounts have gone up significantly in the past few years. A few years ago, it was common to see ransom demands of maybe 50,000 or 100,000, and now it's very common to see ransom demands in the millions. We've also seen that it is more common for cyber incidents to involve data theft only, and actually not involve the spreading of the virus that is normally associated with ransomware. The last bullet on the screen, if you just press the next one, is also that in the past year or so, we've also noticed that more clients are hesitant to pay hackers to prevent the publication of data only. Maybe a few years ago it was more common, but we've seen some increased hesitancy to pay for only data non-publication. As a last note on this issue, and as a callback to a point that Alex made at the beginning of the webinar, we've seen a lot more law enforcement activity related to trying to prevent ransomware attacks in recent years. And some of this activity has been helpful to organizations in preventing and responding to ransomware attacks. I'll now pass it over to Nareg to discuss some issues and trends we've seen in Quebec, which as of September 2022, as you've heard throughout this presentation, has a new privacy law that requires reporting and notification related to breaches.
Thank you so much, Daanish. So Quebec did introduce its own notification regime for what they call confidentiality incidents. Of course, ransomware incidents, when they involve data access or data theft, constitute confidentiality incidents. So since September 22nd, 2023, what's happened? So in the summer leading up to it, we had draft regulations that came in. Super interesting. They were never adopted on time for September 22nd, but they did come to force in December 2022, providing guidance on the content and the means of reporting to the Commission d'accès à l'information on notifications to individuals and on breach record contents, much like it's been done under PIPEDA through the breach reporting regulations. So I'd love to present you with some stats, and can you please click to make the next two elements appear? So far we do know that roughly 30 organizations have declared incidents in the first 2 months leading up to it. So how do we know this? There's been access to information requests by journalists throughout the first 2 months. And the Commission d'accès à l'information has not only been providing stats, but has been providing the names of organizations who reported incidents. So naturally, sharing of names can be undesirable for a variety of reasons. So for instance, Alberta's breach notifications are public, but they also speak to the facts about the case, so you have an idea of what's happening. Federal commissioner does not publish names. Every regime has its way of dealing with it. So far, we think that providing a name would potentially have a chilling effect on breach reports. It may erode the trust that commissioners wish to establish with civil society. So commissioners all of a sudden changed their mind. There's been an article that was published recently saying that, at least much to the dismay of journalists, that the Commission d'accès à l'information decided to change their mind on it. They are no longer releasing the names of organizations that have experienced confidentiality incidents and have reported the situation to the Commission d'accès à l'information. So that being said, organizations are reporting incidents because they have to, and not necessarily because of the fine. So when the law came into effect, next bullet, please. There's been a lot of talk about the size of the fine. Sizable fines, $25 million or 4% of annual turnover, $10 million of administrative monetary penalties, 2% of global annual turnover. That being said, that's not the real issue. Right now, those fines don't come into effect until September 2023, but organizations are reporting it for two key reasons. One is avoiding greater risk of scrutiny by the regulator who is invested by new powers to inquire as to the practices of organizations. And second of all, well, in terms of data breaches, especially in case of ransomware, we have actual harms or potential harms to individuals, and that's what we want to try to avoid by affecting notifications to individuals. So next bullet, please. Finally, as just a point of interest, the Commission d'accès à l'information has been invested in new powers to order measures to reduce the risk of harms to individuals following an incident, so after they receive a report. But to our knowledge, these powers have not yet been exercised, and we are 9 months into them having these powers. So we are looking closely to see how they will exercise their powers, to inquire on certain measures that have been in place, how to investigate breaches, and perhaps a broad range of other powers that they do have. That being said, the Commission d'accès à l'information does not work alone. Next slide, please. Most breaches and investigations are multi-jurisdictional. The nature of internet and e-commerce and the way data is being spread is naturally multi-jurisdictional, traverses borders. And we heard today about TikTok, about ChatGPT. Maybe you guys heard about Tim Horton's Clearview that happened last year. So we really want to highlight that the Commission d'accès à l'information, and honestly, all regulators across Canada have been collaborating more and more. And I want you to keep that in mind as Daanish continues with his expose on multi-jurisdictional breach issues. So with that, I'll hand it over to him.
Thanks. If we could just click for the next couple bullets, that'd be great. So yes, as Nareg said, multi-jurisdictional breaches are quite common, and given the new Quebec law that we discussed, multi-jurisdictional breach issues are becoming even more common. So Canadian organizations used to focus on the federal and the Alberta law because those were the ones that required mandatory notification. Now Canadian organizations also have to consider the Quebec law and potentially other laws that may come into force in the future. There are also, of course, breaches that can be across countries, and similar issues may arise, not just within Canada, but across countries. In a few minutes, for example, you hear from one of our lawyers, Julie, who has expertise on GDPR, the European privacy law, and has assisted organizations in dealing with those kind of issues. Some of the things to consider when you're dealing with a multi-jurisdictional breach, either within Canada or across countries, are the differing breach standards that may apply. So you've heard that the Quebec privacy law requires notification if there's a risk of serious injury, whereas the federal and Alberta law require notification if there's a real risk of significant harm. Some jurisdictions, for example, some US states, may not have a risk of harm standard. They may just require notification if there's a breach, period. Even if there is the same standard in multiple jurisdictions, another point to keep in mind is that the standard may be interpreted differently. So for example, the Alberta regulator may apply the real risk of significant harm standard differently than the federal regulator might in a particular case. Additionally, it's important to note that different laws may apply to different types of personal information. So for example, the federal privacy law does not apply to employee information generally, whereas the Alberta law does. Some foreign privacy laws may not apply to certain organizations or to certain types of activities as well. So those are all interesting things to note and consider when you're dealing with a multi-jurisdictional breach. And so when you're facing that kind of a breach across jurisdictions, you have to think about all these differences and consider how they have implications for consistency. So for example, if you're dealing with a multi-jurisdictional breach and there's a privacy law in another country that does not have a risk of harm analysis, will you notify an individual in Canada, even if there's no risk of harm to them, because you're notifying a similarly situated person in that other country, or not? And there can, of course, be legal implications and risks if you use an inconsistent approach. Lastly, we just wanted to note that when you're dealing with a multi-jurisdictional breach in Canada, some of our clients have chosen to report as courtesy to certain regulators. So for example, the BC privacy law, which you heard from Rachel about, does not have a mandatory notification requirement, but some of our clients have decided that since they're reporting into other regulators in Canada, and since there's a significant number of individuals affected in BC, they will provide courtesy to reporting to the BC privacy regulator. This was also done in Quebec prior to the new Quebec law coming into place. So I'm going to now pass it off to Heather and Hashim, who are going to speak on a discussion about health privacy.
Thanks very much, Daanish. So as you can tell by the words of my colleagues, a new area of privacy law is upon us in Canada. We expect provincial health privacy regimes to evolve in line with the robust and comprehensive legislative reforms seen in Quebec and proposed at a federal level. And some legislative developments have already demonstrated that in Ontario, Quebec, and British Columbia. In March 2020, the Ontario government made various amendments to the Personal Health Information Protection Act, PHIPA, one of which was to provide the Information Privacy Commissioner of Ontario with the authority to impose administrative penalties on any person who contravenes PHIPA or its regulations. These proposed regulations have now been published, stating that the maximum amount of an administrative penalty may not exceed $50,000 for individuals and $500,000 for organizations, except that either amount may be increased by an amount equal to the economic benefit acquired by or accrued to the person as a result of the contravention. Proposed regulations also outline the criteria that the IPC must consider when determining the amount of this penalty. These proposed regulations have been published in Ontario's regulatory registry, and the Ministry of Health is accepting public comment on them by the end of July. Also, in this past February, the government introduced Bill 60, the Your Health Act, to build on the initiatives laid out in Your Health, Plan for Connected and Convenient Care proposed by the Ontario Minister of Health earlier this year. As part of this work, amendments were proposed to the Freedom of Information and Protection of Privacy Act, or FIPA, to operationalize a consistent enterprise approach to data integration, ensuring that all data integration units, internal and external, are subject to similar requirements, including those related to privacy, transparency, and accountability. These amendments received royal assent last month, but the date of them coming into effect is yet to be announced. Next slide, please. Thank you. Now, probably the most important and the most monumental has been the introduction of Bill 3, Quebec's first comprehensive health privacy legislation, which received royal assent a few months ago. The bill is modeled on a personal health information laws of other Canadian provinces, but contains several unique requirements that are directly inspired by Bill 64, Quebec's privacy reform legislation that came into effect last year. Bill 3 establishes a government's model based on transparency and on the responsibility and accountability of service providers and bodies in the health and social services sector. Now, in the bill, health information is defined broadly as any information that allows a person to be identified, even indirectly, and that has any of the following characteristics. It concerns a person's physical or mental health state. It concerns any material taken from the person in the context of an assessment or treatment. And it concerns the health services or social services provided to the person. In addition, any personal information that appears in a file along with the health information that I just defined is considered health information by extension as well. Now, most notably, Bill 3 provides that health information cannot be processed without the individual's express consent unless authorized by law. Bill 3 also introduces numerous new legal obligations, many of which mirror what is found in Bill 64, including mandatory breach notification and the appointment of a data protection officer, and the need for privacy impact assessments in certain situations, as well as restrictions related to the access of health information by individuals, the transfer of health information outside of Quebec, and restrictions relating to the use and application of certain technologies, including automated decision-making. Bill 3 also puts an importance on the quality of services offered to the population by enabling easier access to health data for research purposes. Now, as mentioned, it received royal assent a few months ago, and there's no date has been given for when the bill will come into effect, but it's anticipated to happen in the next 12 to 18 months. Lastly, in British Columbia, Bill 22 made significant amendments to the British Columbia's Freedom of Information and Protection of Privacy Act when it came into effect in November 2021. However, 2 amendments were held back that have come to force as of this past February. The first at a public body is to give notice of a privacy breach to any affected individual that could be reasonably expected to suffer significant harm, and also to the Office of the Privacy Commissioner, Office of the Information Privacy Commissioner of British Columbia. The second amendment requires that all public bodies have a privacy management program in place designed to ensure that public bodies appropriately manage and are accountable for protecting British Columbia's personal information. Now, the Office of the Information Privacy Commissioner of BC has provided additional guidance documents that contain additional information and considerations on how organizations can implement appropriate practices to comply with the new obligations under the Act. Next slide, please. Now, of course, with the introduction of Bill 64 in Quebec and the proposed Bill C-27 at a federal level, we suspect there will be many additional changes and a trickle-down effect to provincial health privacy regimes across the country. As such, we anticipate the next couple of years to include many more proposed legislative updates on the provincial side related to health privacy, and for these changes to align with the language and obligations we have seen in Bill 64 and those that are proposed in Bill C-27. I'll now pass over to Heather.
Thanks, Hashem. So in the health privacy space, we've also been looking at what privacy regulators have been focused on this past year. Next slide, please. And one of the most prominent and continuing themes relates to digital care, and specifically how health sector participants can build trust in digital care by ensuring that the tools and the digital technologies they're using to handle personal health information really respect and protect patient privacy. So I'll share a few of the opportunities and challenges in this area. The first is a resounding consensus among privacy regulators that it's time to eliminate fax and unencrypted email as methods of communicating health records. Last fall, the federal, provincial, territorial privacy commissioners and ombudspersons released a joint resolution saying exactly that and calling for a very concerted effort across the healthcare sector to modernize and strengthen the security of digital health communications. The joint resolution also loosely coincided with two notable investigations by privacy commissioners in Ontario and in Saskatchewan into privacy breaches and, in fact, patterns of privacy breaches that were caused by misdirected faxes, which we know remains one of the leading causes of privacy breaches in the health sector. And one of the common conclusions that both privacy commissioners flagged in their investigation reports is that remediation efforts to make faxing more secure, for example, by implementing processes to verify recipients or to address bounce backs, are no longer entirely adequate. And at this stage, the appropriate mitigation effort is really a commitment to transitioning away from a technology that poses a systemic privacy risk. And this really confirms the idea that privacy is not at all a barrier to digital innovation in the health space. And in fact, creating a secure and a privacy compliant organization generally requires assessing and implementing new digital tools that can be alternatives, or in many cases, actually improvements to traditional methods of sharing health data. And there's been, I would say, an effort to make this process more straightforward for providers. So, for example, Ontario Health has developed a provincial standard for virtual care solutions, where vendors can either self-assess or they can opt to undergo scenario-based testing to demonstrate that their virtual care solution can meet certain privacy and security and interoperability requirements. And then clinicians and service providers who use that technology platform can be confident that they're using a tool that's been appropriately vetted. Next slide, please. Finally, one of the benefits of digital care that I wanted to flag is that it often gives patients greater control over their personal health information, which is sort of starting to change expectations around what it means to be able to access information. So, for example, in Ontario last year, there was an amendment to the health privacy law, which provided individuals with the right to access their personal health information in electronic form. And more recently, the Ontario Privacy Commissioner had an opportunity to consider this new requirement in an investigation involving a healthcare provider who said that they simply didn't, in response to an access request, said that they simply didn't have the financial or technological means to provide a patient with electronic access. And the adjudicator concluded that, notwithstanding the fact that the provider was still using a paper-based record system, they did have a duty to explore and to implement appropriate measures to be able to provide patients with access to their records in electronic form. And with that, I will turn things over to Julie and Sam for our final segment of the day.
Thank you, Heather. Let's talk about news in EU or under GDPR. Firstly, as regarding regulation, what's news? In addition with what mentioned my colleague Justin regarding the draft EU AI regulation, we have also a Data Governance Act. Next slide, please. The Data Governance Act was adopted last year and will come into force in September 2023. It aims at promoting the sharing of personal and non-personal data by setting up the intermediation structures. In addition to the Data Governance Act, which has already been adopted, there is a draft regulation on the Data Act. The Data Act aims at clarifying who can create values from data and under which conditions. And both acts the Data Governance Act and the Data Act, aims at creating a single EU data market in addition to the GDPR. Next slide, please. Now, second, what's happening with the data privacy framework? I don't know if you remember, but a few years ago, the EU decision, Schrems II, has invalidated the privacy shield, which enabling the transfer of personal information from EU to the United States. And it wasn't possible at all to transfer personal information to United States, except if you carry out a privacy impact assessment and if you enter into appropriate safeguards. Last year, there were discussions on a new framework, the privacy framework, according to which was a kind of adequacy decision. But unfortunately, if it is an improvement on previous frameworks, the draft adequacy decision, so the data privacy framework, does not provide for sufficient safeguards regarding in particular the rights of data subjects and notably the possibility for US governmental authority to make bulk data collection. So that's why there is no still an adequacy decision for transfer of personal information to the United States, and for the moment we have still to rely on the privacy impact assessment and standard contractual clauses, for example. But wait and see, maybe next year we will have an adequacy decision. Thirdly, what's news on the case law? Well, we had a very interesting case law this year. For example, we recently have a decision on DPOs, the Data Protection Officer in the EU. The European Court of Justice has decided that the DPOs shall act in an independent manner, which is the text of the GDPR, but the DPO cannot be entrusted with tasks or duties which would result for the DPOs by determining the means and the purposes of the processing, which is the definition of the data controller. So this decision makes a distinction between the role of the DPO and the role of the data controller. And the DPO shall be independent of the data controller. If this independence is not ensured, there will be a conflict of interest. Second decision interesting from the European Court of Justice is a decision on Austrian Post, which define the scope of the access rights. In this decision, an individual has asked the Austrian Post to access to his personal information. The Austrian Post gave him only a few information, and the individual make a complaint. And finally, the European Court of Justice ruled that when an individual makes an access request, the company, the data controller, shall inform the individual about all the recipient of his personal information. So it means that if it's possible, the controller shall give the name of all the service provider, for example, handling individual personal information. Let's go to my colleague Sam Delechantos on US matters.
Thanks, Julie. So I'm going to take us on a whirlwind tour of the US. There's been a flurry of activity there in the last few years. A number of states have considered or passed privacy bills. So firstly, there's the California Consumer Privacy Act, and that was recently amended, with those amendments coming into effect on January 1st of 2023. Also in effect on January 1st was the Virginia Consumer Data Protection Act. We also have Colorado, which is effective July 1st, along with Connecticut, also July 1st of this year. And later this year, December 31st, 2023, is the Utah Consumer Privacy Act. Next slide. But it doesn't stop there. We've got Iowa, which comes into effect on January 1st of 2025, Indiana, which comes into effect January 1st, 2026, Tennessee, that comes into effect on July 1st, 2024, and Washington, My Health, My Data Act, which comes into effect on March 31st, 2024. In addition to these laws, some other states like Texas and Montana have newly passed some laws relating to consumer privacy protection, and many other states are considering specific legislation targeting children's data, health data, automated decision-making, and biometrics, some of which my colleagues have touched on today. Next slide. So a brief note on California, with amendments just coming into force and being enforced on July 1st. So this is a kind of threshold applicability. So businesses will only be subject to California laws where they have had a $25 million revenue in any given year. They buy, sell, or share the personal information of 100,000 or more California residents, or they derive 50% or more of your annual revenue from selling or sharing California residents' personal information. So this sort of applicability threshold is generally followed by the other state laws. For example, Virginia, Utah, Tennessee, Iowa, and Indiana all apply a similar threshold of the at least 100,000 consumers and the 50% of gross revenue from the sale of personal data. There are some sort of slight differences between each state, but they follow a similar application. So of note in the California amendment specifically is that employee information and information obtained in a business-to-business contact is classified as personal information of consumers. And as such, those individuals benefit from the same rights as other consumers. So they may request copies of their information, they may ask for their data to be amended, and they may ask to opt out of additional data processing. And there are other notable changes under California that I won't go into detail about today, but I recommend looking into the applicability of the Act as well as the other state acts to determine your business's threshold applicability. And if you are falling under those obligations of California or other state laws, you should look at your technical compliance on the back end to ensure that you are in compliance appropriately. And so next slide. I will just finish off with some key takeaways across all of the laws. Most of the states have similar overlapping obligations and focus on things primarily like transparency, i.e. having notifications to consumers about their collection, use, and sharing of your data, performing risk assessments and impact assessments, and keeping yourselves accountable. So making sure that you have the right contractual obligations in place to hold your suppliers and partners to the same standards as you yourself are held to. So some of the key items which I would suggest looking at is to update your website regarding cookies. Obviously, this is nothing new for the EU, but in the US, especially in California, the regulators are looking at the ability of consumers to opt out especially of cookie tracking for the purposes of behavioral advertising and profiling and marketing. So you should update your website to ensure that you have a cookie banner, that you're allowing people to opt out, that you are tracking those opt-outs on the back end, and that you are also ensuring that you are receiving preference signals from browser add-ons like the Global Privacy Control. In August of last year, the California AG brought their first public action against the business for alleged failure to process do not sell requests via the Global Privacy Control. So there has been some focus down there on that. So second one, I won't go into too much detail because my colleagues have already covered it, but conducting data protection impact assessments, or also known as privacy impact assessments, are also required under many of the state US laws. So keep that in mind. Update your policies. So I would go back and review all of your privacy policies. There are specific notices required in each state, noticeably California and Virginia, specifically most recently have notification requirements, as well as specific rights that you need to alert individuals of. So make sure you also update your employee privacy notices for the California requirements. I would also suggest you review your data subject request processes, as individuals have these rights that they're constantly able to, ask your business to comply with. You need to think about how you're going to respond to those requests on your back end. Do you have the technical capabilities to provide people with copies of their data? Do you have a way to identify where people's data is being held across your entire organization and to delete it appropriately? So keep that in mind when you're reviewing your business practices, as well as revising your contracts. Obviously, as I mentioned, there's specific contractual requirements for you to have with your service providers, specifically in California and Virginia. So you need to review your contracts to make sure you're including those obligations appropriately. And lastly, ensure you're evaluating your business to see whether you are processing sensitive personal information. And that definition does change between states. So make sure that you get advice on whether you are processing that information. Next slide. And obviously, if you need help with compliance, because I did touch on these topics only very quickly today, but please reach out. We can help with that. And next, I will hand over to my colleagues Antoine and Jennifer to give some closing remarks.
Thank you. With Jennifer, who's a former Privacy Commissioner of Canada, we are now at the section Words of Wisdom. And my question to you, Jennifer, we see with all the presentation today, a lot of movement in the privacy world. We have a new Privacy Commissioner who's now came into office a year ago. A lot is going on, and what I wanted to have your thoughts on is, what are these changes, all these movement? What are the impacts on client? What are you foreseeing in the next year, and what should our client put forward or prioritize right now?
Yeah, thanks, Antoine. I don't know how wise this observation is, because I think everybody will already have made it, but if you look at everything people have been talking about in the last hour and a half, we're witnessing an ever accelerating convergence of data protection or privacy law reform, of policies. What's happening here is happening there. The details are slightly different. And this is happening at a really, really rapid pace. We're also looking at a new generation of enforcers, starting with Commissioner Dufresne, who are, I'd say, very, very sophisticated, have sophisticated staff, are looking for efficiency, and they're looking for cooperation, whether it's domestically or internationally. So there's kind of nowhere to escape to from the long hand of data protection rules, regulations, and so on. There's a tremendous network that's grown out there. So this is new in a generation. You used to say, oh, if you go there, you've got this, and the EU and so on. No, it's pervasive now, and the regulators are making it pervasive.
And where do you see our clients, where they should put their priority? We heard about a lot about knowing yourself, knowing the data flow of personal information, but what are your thoughts for our clients?
Yeah, I think that clients should go back to the basics, because the details are slightly different in every jurisdiction. And if you're involved in that jurisdiction, you have to look at the details, but you have to make sure your clients develop a culture of privacy. If you have a culture of privacy, you won't get yourself into these situations Home Depot did, or the organization in Ontario that couldn't give access to personal information. And if you start with that, I think you'll put yourself in a good position for whatever comes along.
And avoid the multi-million fines that may be brought against corporations starting in September, right?
Yes, I think attitude counts for a lot when you're dealing with regulators. But you're also seeing regulators now that are not, they don't want to set exemplary fines, at least not in Canada. They don't want to get organizations. They want to make sure that the privacy rules, the data protection rules are observed, and they're willing to sit down and talk about how that can be done.
Well, one of the good news is that the regulators are not financed out of fines, so it won't change anything on their resources.
Yeah.
Thank you, Jennifer, and thank you everyone for attending on behalf of Alex and I and the whole privacy and cybersecurity team. We want to thank you for joining us in great numbers. We continue to be in attendance, all of our Fasken colleagues, and we're really proud of that. It will be a pleasure to assist you if you have any needs for advice or representation. Last thing, if you didn't get a chance to fill in our survey, we would appreciate if you took a moment to do so in order to better improve ourselves. And we'll see you next year with the recent trends that will be developing in the next few months. Thank you.